Hello, and welcome to the Texas Regs Educational Series. This session is being recorded and will be posted on the texasregs.org webinars page if you want to review the content or share the information with your friends and colleagues. We have two speakers today, Terry Alexander and Cole Johnson. They will be speaking about HIPAA Omnibus Rule, changes to BAAs, incident reporting, and notices. All attendees have been muted to block out background noise. If you have questions for our speakers, please post them in the chat block of the GoToWebinar pane. Your questions will be read to the presenters at the end of the presentation. If we are unable to answer your questions during the allotted time, you will receive an answer via email. First, some information about our speakers. Terry Alexander earned a Bachelor of Science degree from the University of Texas at Dallas, where he majored in Accounting and Management Information Systems. Soon after graduation, he obtained 3 copyright for software directly related to the financial sector. Mr. Alexander enjoyed a lengthy career as a senior manager specializing in project management and data warehousing for a Fortune 100 company. In 2008, Mr. Alexander and his family moved to their farm in West Texas. Hired by the Stanford Memorial Hospital as the Electronic Health Records Project Manager and IT Manager, the hospital successfully attested to have achieved meaningful use in April of 2011. Currently, Mr. Alexander leads the West Texas HIPAA efforts in supporting critical access and rural hospitals in their efforts to attain meaningful use of electronic health records. Cole Johnson attended Arizona State University in his hometown of Tempe, Arizona, where he graduated cum laude with a BS in communication and a minor in business. After graduating from ASU, Cole attended Texas Tech University School of Law. During his tenure at Texas Tech, he was the executive lead articles editor for the Texas Tech University School of Law Administrative Law Journal. Prior to joining the West Texas HIPAA, Cole worked as an associate attorney at a law firm in Lubbock, Texas, where he concentrated in civil litigation. Currently, Cole assists the West Texas HIPAA in providing program management and administration of healthcare provider technical assistance agreements, contract analysis, contract negotiations, and ensuring compliance with regulatory requirements. Thank you for joining us, and I will now turn over the webinar to Cole and Terry. Cole, the presentation is yours.
All right, I'll pull up my. Karen, I prepared a PowerPoint for this presentation. Can you guys see it?
Yes, we can see it.
Sounds good. Well, again, I'm Cole Johnson. I'm at the West Texas Regional Extension Center, which is part of Texas Tech University Health Sciences Center. The Regional Extension Center is part of a federal funded program. I don't know if you're aware of regional extension centers or not, but it's a federal program to help healthcare providers implement electronic health records into their practices. So that's what Terry and I do, is support that program, and we cover the West Texas region. It's 108 counties in West Texas, and we've been working with providers in the last 4 years under that initiative. Today we're going to talk about Health Insurance Portability and Accountability Act, the final rule that came out last year, and then the Texas Medical Records Privacy Act, which was amended under House Bill 300 in the 82nd regular session in Texas in 2012. I'd like to apologize for the timing of this presentation. I know coming up a holiday weekend is hard to get back in the swing of things and focus on such exciting and interesting topics such as HIPAA and the Texas Medical Records Privacy Act. However, we'll tackle these today and go through them, provide a basic overview to help you learn a little bit more about these regulations and what you can do to bring your practices, either if you're a covered entity or a business associate, into compliance if you're not already so, or if you are in compliance, to help you continue to hone your compliance skills in these areas. And just a disclaimer, these are highly regulated areas. So just so you guys know, this is for educational purposes and not legal advice. So don't rely on anything Terry or I say take it back to your practice and say, well, Cole and Terry said this, so this is what we're doing. It's just to educate you, not as a basis for you to rely on legally. All right, so starting off, some important dates regarding HIPAA. The Omnibus Final Rule became effective on March 26, 2013. These were, under the Final Rule, include provisions to update HIPAA, and we'll go through some of those provisions today. But that was the effective date. The compliance date was September 23rd, 2013. However, there was a grandfather provision. If you had an existing business associate agreement that was compliant with the prior HIPAA provisions prior to January 25th of 2013, and you didn't renew or modify that agreement between March 26th and September 23rd of 2013, you're eligible for that grandfather transition period until September 24th to bring your business associate agreement up to date with the new HIPAA provisions. My suggestion is, though, although that's just a couple months away, if you have not already done so, go ahead and start looking at your business associate agreements now to modify them and make sure that they're up to date. Take these next couple months to try to get in compliance. That way you'll be fully compliant by the September 24th date. All right, so just a basic overview of the effects of the final rule. Basically, the final rule modified the privacy, security, and enforcement rules to implement what was brought under the HITECH Act. It also expanded the definition of business associates. It requires updates to business associate agreements, and it changed the breach notification provision. So we'll discuss these topics today through this presentation. All right, so just initially we'll cover some definitions. A covered entity, now this wasn't updated through the final rule, but it's always good to know what a covered entity is because that's the main thing that the HIPAA provisions apply to. It's a health plan, healthcare clearinghouse, or healthcare provider that transmits electronic personal health information in connection with the certain standards for which HHS has adopted, or certain transactions for which HHS has adopted standards. And we'll sort of talk about later in the presentation how Texas has broadened the definition of covered entity to be more expansive than what is covered under HIPAA, just for comparison. Oops. All right, and then business associate, like I said, the Omnibus Final Rule expanded the definition of business associate. Basically, a business associate, or a BA, is any person other than the workforce members of the covered entity, such as volunteers, employees, or trainees, that creates, receives, maintains, or transmits protected health information, or PHI, on behalf of the covered entity, or who provides services to or for the covered entity involving the disclosure of PHI. It includes, and these are new, health information organizations, e-prescribing gateways, patient safety organizations, data transmission vendors, personal health record vendors, and subcontractors. The biggest, I guess, inclusion to consider under the definition expansion is subcontractors. But basically, I was talking about the definition of business associate being expanded. Includes any person that maintains, transmits, that creates, receives, maintains, or transmits protected health information on the behalf of a covered entity. And then I talked about the new expansion includes health information organizations, patient safety organizations, e-prescribing gateways, data transmission vendors, personal health record vendors, and subcontractors. And the biggest thing to keep in mind for the subcontractors is many subcontractors might have not felt that the HIPAA provisions affected them prior to the final rule. However, under the new provisions, subcontractors are included as a business associate, and so all the requirements that apply to business associates apply to any subcontractors that create, receive, maintain, or transmit PHI for and on behalf of business associates. So the definition is pretty expansive under the final rule. There are some narrow exceptions, one of them being if you're an entity acting as merely as a conduit of information, such as an internet service provider, or you're the phone provider for a fax machine, you won't be considered a business associate. But pretty much anyone else that creates, receives, maintains, or transmits PHI is now included under the provisions of the final rule. All right, some additional points on business associates. Historically, the liability from a business associate stemmed from their contract with the covered entity pursuant to the terms of the business associate agreements. But now, under the final rule, there's direct liability imposed upon the business associates for failure to comply with HIPAA, including any impermissible uses and disclosures of PHI, failure of the business associate to comply with the security rule, failure of the business associate to provide breach notification to the covered entity, or if you're a subcontractor to the business associate above you, failure to provide access to a copy of electronic PHI to the covered entity, the individual requesting their PHI, or their designee. They could be liable for failure to disclose PHI where required by HHS, or failure to provide an accounting of disclosures they've made regarding PHI. So prior to the final rule, unless those were included under the terms of the BAA, the business associates didn't really have to worry about these provisions as far as being liable for them. But now there's direct liability regardless of whether the covered entity and the business associate puts these related terms into the agreement itself. The business associate may still be liable directly for failure to comply with these HIPAA provisions. All right, so note on subcontractors. Like I said, subcontractors are now included as a business associate under the definition, and they're basically any person or entity to which a business associate delegates a function, activity, or service in a capacity other than a member of the business associate's workforce. And they're directly liable and obligated to comply with the requirements of HIPAA, just as in the same manner as a business associate would be. All right, so what does this mean to business associates? So we know that the definition has been expanded. Entities that might have not thought they were included in complying with the HIPAA provisions are now included. So what do you need to do if you're a business associate? Well, first off, you need to adopt a health information privacy and security program to include and implement policies and procedures just as in the same manner as a covered entity would, which includes implementing administrative, physical, and technical safeguards to be in compliance with HIPAA. Business associates will need to conduct required risk assessments. They need to make sure that they amend their existing business associate agreements with their current covered entities and subcontractors to make sure that those agreements are in compliance with the new provisions under HIPAA. They need to identify and enter into sub-EAs with their subcontractors. So many times there might be a business associate that had subcontractors that weren't covered under the definition as a business associate before the final rule. And so now business associates will need to reanalyze those agreements and see whether or not a business associate agreement would need to be in place with those subcontractors. And also business associates will need to appoint and hire privacy officers and security officers. So let's talk about the impact the final rule has on the business associate agreements themselves. So prior to the final rule, covered entities need to have a written business associate agreement in place that basically required the business associate to safeguard PHI and to not use or disclose PHI in any other manner than what was provided for in the business associate agreement itself. And then also the contract needs to ensure that any subcontractors agree to the same restrictions that were imposed on the business associate. Now, the business associate agreement is still required, but the business associate must also comply with certain privacy and security rule requirements, like I talked about before. Even if you don't put these requirements in the business associate agreement itself, it does not mean that you as a business associate is not liable for those privacy and security rule requirements. You're directly liable now under HIPAA provisions. So whether or not you contract for those or not, you'll still be liable for complying with those provisions. Business associates must report to the covered entity any breach of unsecured PHI as required by the breach notification rules under HIPAA. The business associate must enter into business associate agreements with subcontractors, imposing the same obligations that apply to the business associate. They must also comply with the privacy rule. And the one thing that they don't have to do anymore is they're not obligated to report to the Secretary of HHS if a breach of a business associate agreement cannot be cured and terminated, and termination of the agreement is infeasible. So I guess we got a little bit of a break there with all these other requirements that we now have to follow. All right, so I've listed some things to include in a business associate agreement. I won't read through all of these. We'll make these slides available to you guys after the presentation. But under the expansion of HIPAA, these are requirements that you'll need to evaluate your current business associate agreements to see if you have these provisions in your agreements, and if not, this is what you need to amend to bring your business associate agreements in compliance with the HIPAA Omnibus Final Rule. There's 2 slides that cover this information here. Alright, so steps to amend your business associate agreements. These are some practical steps that, as a business associate or a covered entity, that I suggest you would take to help you understand whether or not you need to amend your agreement or if you need an agreement in the first place, and what you need to do going forward from there. So first off, evaluate who you are. Are you a covered entity? Are you a business associate? Are you a sub-business associate? And we posted a link to a business associate decision tree to help you determine whether or not you are a business associate or not. The second thing I would do is create a list of all the entities and vendors that you contract with and assess whether or not there's PHI involved in those agreements. If you have an agreement with like a vendor that comes into your office to stock your candy and soda machines, you won't have to worry about a business associate agreement in place because it doesn't cover PHI. So evaluate all your agreements that you have at your facility and your practices, determine whether or not PHI is involved, and if PHI is involved, those are the agreements you'll need to tackle on determining whether or not you need to update your business associate agreements, or if you don't have one in place, if you need one in place. So that's the next bullet point. Determine if you currently have those agreements in place, and if not, determine whether or not they are needed. If you decide that you need to amend your agreements, or if you need to establish new agreements with business associates, please engage your counsel to review your business associate agreement against the final rule provisions and drafting needed updates. And there's a sample business associate agreement that the Office of Civil Rights has maintained and posted on its website, which there's a link available there to review that as well. That's sort of a template to get you started. I've also included some additional terms to consider in a business associate agreement. If you're a covered entity, you want to make sure that you state that the business associate is acting as an independent contractor. And we'll talk about this a little bit more, but there's some liability that can attach to a covered entity if it is found that the business associate is acting as the covered entity's agent. And so you'll want to distance yourself as much as possible if you're the covered entity from being considered, or having the business associate being considered as your agent. The hard thing is, even if you contractually state that the business associate is not your agent, if the facts or the circumstances show that they are your agent, it doesn't matter what you put in the contract, they'll still be considered your agent as far as liability is concerned. So not only do you want to put that in your contract, but also act in a manner that the business associate is not acting as your agent. You want to include insurance provisions, indemnity agreement provisions. You want to have specific term and termination provisions. You want to make sure that you have the availability to amend the business associate agreement to accommodate changes to HIPAA in the event that HHS decides to continue to modify the HIPAA provisions. And you want to include choice of law and venue provisions. If you have vendors that are located in other counties or other states, you don't want to be dragged to litigation throughout the country. So just depending on where you want to litigate any matters that might become a dispute, include those choice of law and venue provisions. If you're the business associate, you want to make sure that you have provisions that prohibit the covered entity from taking any actions that would violate the HIPAA rules, or that would restrict the use or disclosure of PHI that might adversely affect what you do as a business associate. In addition, you want a clause that allows you to terminate your agreement if the covered entity agrees to any restrictions that prohibit or restrict you from performing or increases the cost of your performance. And although a covered entity will want to include insurance and indemnification agreement provisions, as a business associate, you'll try to get those out of your agreement. All right, so talking about the covered entity liability, in relation to the business associates. A covered entity is considered to have violated HIPAA if the covered entity knew of a pattern of activity or a practice of a business associate that constituted a material breach or violation of the business associate agreement, unless the covered entity took reasonable steps to cure the breach and the violation or terminate the contract. So as a covered entity, you sort of need to police what your business associates are doing, and if you notice a pattern of activity or practice as violating the business associate agreement, you need to make sure that you take the steps to cure it and the violation or terminate the contract. Because if you don't, and the business associate continues on that pattern of practice, you could be liable under HIPAA for failing to act accordingly. In addition, in regards to the agency provisions, a covered entity may be liable under agency law if it's determined that the business associate was acting as an agent of the covered entity. So again, you just want to make sure, if you don't want to be tagged for being liable for the business associate's actions and what they're doing, try to distance yourself and not be their agent to the extent possible. And business associates to be aware as well that they can be liable for violations of their subcontractor agent acting within the scope of the agency. So it not only pertains to covered entities and business associates, but business associates and their sub-business associates. All right, we're going to switch gears a little bit. So we talked about the expansion of the omnibus final rule to the definition of the business associate. We talked about what's now required of business associates. We talked about what to include in business associate agreements. Now we're going to talk a little bit about what the final rule requires for the breach notification rules and the changes that it made to breach notification provisions. So basically, the definition of a breach is the acquisition, access, use, or disclosure of PHI in a manner not permitted under the privacy rule, which compromises the security or privacy of the PHI. In the event that a covered entity discovers a breach of unsecured PHI, they'll need to notify each individual whose unsecured PHI has been or is reasonably believed by the covered entity to have been accessed, acquired, used, or disclosed as a result of the breach. Now the final rule presumes that any impermissible acquisition, access, use, or disclosure of a breach or of disclosure of PHI is a breach unless the covered entity or the business associate can demonstrate there's a low probability that the PHI has been compromised. So now, if you're the privacy officer at your practice, you get to do a fun analysis if there's a breach to determine whether or not there's a low probability that the PHI has been compromised. So here's the analysis that you need to take. It's a 4-step analysis. Basically, it's a risk assessment that you need to take if there's a breach. And the 4 factors to look at are the nature and extent of the PHI involved, the unauthorized person who used the PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed, the extent to which the risk to the PHI has been mitigated. And you need to make sure that your risk assessment is thorough, complete, in good faith, and has reasonable conclusions. And if after your evaluation, if you conclude that there's a low probability that PHI has been compromised, then you don't need to provide breach notification. However, if you conclude that the factors fail to demonstrate there's a low probability, then you will need to provide breach notification. One thing to note is you do not have to do this 4-factor test. If you feel you want to avoid this test and just go ahead and provide the notifications, you can do so without doing the risk assessment. So that's something to consider when you're developing policies and procedures regarding the final rule, is whether or not you as an entity want to just go ahead and provide the required notifications in each and every event of a breach, or if you're going to perform the risk assessment, or if there's something that you'll look at to determine whether or not you want to go ahead and provide the notifications or perform the assessment. So that's up to your practice to decide what you want to do in those situations. We're going to talk about the steps to take when a breach occurs. So as far as the discovery period and when does the clock start, a breach is treated as discovered by a covered entity on the first day the breach is known, or by exercising reasonable diligence would have been known to the covered entity. In regards to a business associate, if there's a business associate that discovers the breach, if the business associate is determined to be the covered entity's agent, the clock starts ticking on the date that the business associate discovered the breach. However, if the business associate is not determined to be the agent of the covered entity, the business associate has 60 days to report to the covered entity, and the covered entity has 60 days from the date they're aware of it, or the date that the business associate reported to the covered entity to act upon that breach. And so one thing, if you're a covered entity, to put in your business associate agreements is specific dates rather than the 60 days. You might want to shorten that time period to, if a business associate discovers a breach, to when they have to report the breach to you as the covered entity. So within 60 days of following the discovery of a breach, the covered entity must notify affected individuals in written form, by first-class mail, or by email if the individual agreed to receive such notifications electronically. If the covered entity has insufficient or out-of-date contact information for 10 or more individuals, you have to provide substitute notice by posting notice of the breach on your website for at least 9 days, or provide notice in the media. And a couple of points on providing notice to the media. The requirement is that you provide notice to the media. You don't have to ensure that the media actually does anything with the notice that you provide them. So you might provide notification of the breach to the media outlets, and the media outlets may or may not decide to actually broadcast that notification. But you're compliant just on the fact that you provided the notification to the media. One thing you can't do is create a press release and put it on your website and call that good. You have to actually distribute that press release to the media channels. If you experience a breach that affects more than 500 residents of the state or jurisdiction, in addition to notifying those individuals, you're also required to provide notice to the prominent media outlets no later than 6 days following the discovery of a breach, and post notice to the HHS website, otherwise known as the wall of shame. So there's a website link here. We can go on, and if you do experience a breach, hopefully you don't, affecting more than 500 or more individuals, you'll have to post notification of that breach on this website. And it's been tracking these breaches since 2009. Now there's a safe harbor provision regarding a breach of PHI. If the PHI that was disclosed or unauthorized access was encrypted, then you do not have to provide breach notification so long as it was encrypted in accordance with HHS guidance. So that's one thing to be aware of. You know, many of the breaches that occur involve stolen laptops or other electronic devices. So as a covered entity or business associate, to the chance that you can encrypt those electronic devices to the extent possible, I would go ahead and do that so you can fall into the safe harbor provision and avoid dealing with the breach notification provisions. Just a quick note on the HIPAA violation liabilities. It's a tiered system of liability based upon whether or not the actions of the covered entity or business associate were knowingly or with reasonable cause, and not due to willful neglect, with willful neglect, or willful neglect that wasn't corrected. And just some examples to sort of give you an idea of what might constitute an action that would involve the monetary penalty for reasonable cause and not due to willful neglect. One example might be if you're a covered entity and receive an unusually high demand for requests for copies of individuals' health records, but you can't process demand despite your good efforts, just because the request is so numerous that you might not be able to get to them all on time. Although you tried, you don't meet the definition of reasonable cause, not due to willful neglect, and be liable for these monetary penalties. An example of willful neglect that was corrected within the time period could include failure to conduct written risk analysis or conduct or training could qualify as willful neglect. And one thing in regard to the breach notification, the OCR may impose civil monetary penalties against entities for failing to comply with the breach notification requirements. Additionally, because each breach of unsecured data involves impermissible use or disclosure of the privacy rule, OCR may also include a civil monetary penalty for the privacy rule violation, even if you comply with the breach notification provisions. So there's a lot of specifications regarding these liabilities, so that's one thing to take into consideration. You might be compliant with the breach notification provisions, but because the underlying reason why you had to provide the notification was due to a violation of the privacy rule, you can still also be liable for those violations in the privacy rule. So there's some practical tip regarding breaches is review and update your policies and procedures. Train your staff on your updated policies and procedures. So it's one thing to have the policies and procedures updated, but it's also another to make sure your staff is trained on them, including what to do for reporting, evaluating, and documenting breaches. Prepare an incident response team consisting of privacy officers, attorneys, budget and finance managers, and any outside contractors, and designate a communication spokesperson so that in the event of a breach, your team's ready to go and act upon it so you guys don't have to worry about not being compliant with the breach notification provisions. And with that overview of HIPAA and final rule and some of the updates to the provisions, I'd like to turn the time over to Terry so we can talk a little bit more about what Texas requires as far as the privacy of medical records in Texas.
Thank you, Cole. That's a lot of information to go over in that amount of time. The Business Associates Agreement and the Omnibus Rule is complicated. You did a great job on that. Our great state of Texas says, well, if the feds can find everybody, why can't we take a piece of the action? So they did. Texas House Bill 300, it in itself is not a law. What the Texas House Bill does, and we'll go into this later, is it modified existing statutes. The effective date of the House Bill 300 was September the 1st, 2012. Texas also is much broader in scope than HIPAA, and it not only applies to, as the slide says, to the healthcare providers, but just about anybody that touches, stores, or possesses PHI. Next slide, please. What House Bill 300 did is it modified the Texas Health and Safety Code, the Texas Business Commerce Code, Insurance Code. It impacts almost all Texans. There's massive fines for violations. There's an Attorney General website to report violations. It requires documented training, and the state has the ability to seize medical records. Next slide, please. The covered entity, Texas also defined this, and it went very broad, and it says it's anybody that assembles, collects, analyzes, uses, evaluates, stores, or transmits PHI. Anybody that comes into possession of PHI. Anybody that stores PHI. And anybody that's an employee, an agent, or a contractor of anybody else that is using or touching touchy-feely PHI. Next slide, please. In other words, the effects of House Bill 300 impacts you, everybody. I think a very, very good example is the summer is here, and some folks are sending their kids off to summer camp. And when your kids go to summer camp, they've got this sheet that they fill out. Are they allergic to any foods? What kind of medicine are they taking? Can they swim? All kinds of stuff. That is PHI, and that camp counselor is responsible for protecting that PHI and can be held accountable for any breach of that PHI. So just think about it. Anybody at your camp, at your school, at your church, anybody. It affects everybody. Next slide, please. The restricted activities under the TMRPA is that unauthorized disclosure is an action to release, transfer, provide access to, or divulge information outside the entity holding the information. Again, Texas went very, very broad on this. It says that covered entities may not disclose PHI in exchange for direct or indirect remuneration, which means you can't sell it, except the disclosures are, and you'll hear this a couple of times, for the treatment, payment, healthcare operations, or performing healthcare maintenance. In other words, for doing everyday business. Remuneration for providing somebody information cannot exceed the entity's reasonable cost for preparing or transmitting that. And I love that. It cannot cover a reasonable cost. Well, who defines what a reasonable cost is? Very, very, very great. Next slide, please. The consumer has rights that you have to provide an electronic copy of your electronic health record within 15 days of a written request unless they agree to accept it. Then I love this next bullet. The Attorney General has a website for consumers that want to blow the whistle on a breach, a complaint of PHI. Now, when this bill first came out, I was in Austin at a legislative session, and Senator James Nelson was the bill's sponsor. Federally, if I turn Cole in for and saying he's cheating on his income taxes, the IRS will go and look and audit Cole. However, the IRS is going to audit me as being the whistleblower. In the state of Texas, we don't have any protection for if somebody gets mad. If I get mad at here in Abilene, if I get mad at Kendrick's Hospital and decide to complain about them, and there's nothing wrong, except I just put them through the hoop, nothing comes back on me. So I think that is a flaw in the law. But it is there. There is a website to report abuse of PHI. Next slide, please. I love this. You must post a notice that you create or receive PHI. Anybody that has been to a doctor in the past year, I guess, when you walk into the doctor, there are so many notices. In the state of Texas, there's provision for hospitals called 30.06 that you can't take a handgun in there. You have a notice that says either we take Medicare or we don't. We take Medicaid or we don't. You have a notice that says that you expect payment for services the same day. There's so many notices you won't be able to find the address of the business. But you must post a notice, and it must be in the place of business, on a website, or where the PHI is subject to electronic disclosure. And the notice must be conspicuous and understandable. I wonder if you ask the average person if they knew what PHI was, if they knew what it meant. So another vague definition, conspicuous and understandable. Next slide, please. Even if the notice is posted, you still cannot disclose an individual's PHI without their separate authorization. It goes under this. This is the same thing that we were talking about before. The exception is daily in the daily course of business for insurance, for payment, for healthcare operations. Just what I call just the standard course of doing business. And there is a form and a link on that in this presentation. Next slide, please. Originally, the notification said that it applied to only to Texans, but now the state has expanded that, and it's to all individuals whose sensitive personal information was or is reasonably believed to have been acquired by an unauthorized person. You have to, in Texas, you have to give notice of the breach, and the notice may be written notice at the last known address of the individual. If your PHI has been breached, you have to be notified. It doesn't care. Our state doesn't care if it's 1 or 500. Federally, they go into if it's over 500, you have to contact the media, but it doesn't say the media has to do anything with it. It says you have to contact them. Next slide, please. Okay, one of the other modifications to House Bill 300 is that they have to provide training to employees as necessary and appropriate for the employees to carry out the employees' duties. Now, many healthcare providers and hospitals, when a new employee comes on, they sit them in a room and they have them sit down and they watch a HIPAA film, 30 minutes or an hour long. Everybody's done this. The Texas Tech does it for fire safety and chemical handling and stuff like that. And then you sign a piece of paper and say, okay, you've been trained. According to House Bill 300, the training for somebody in dietary could be entirely different from an RN. I mean, as to their access to PHI and how they do it in their job. The training must be completed no later than the 90th day of the date the employee is hired. And if there's a material change in state or federal law concerning PHI, then you have to train everybody all over again within a reasonable period, but not later than the first anniversary date of the date that the change takes place. And then, of course, employees have to sign a statement that says that they've completed it, and that has to be maintained for 6 years. Just like all policies and procedures must be on file for 6 years. Next slide, please. Our great state, we're going to fine you. Also, $5,000. It follows the same tier type structure at the federal level, except ours was a little bit higher. I would notice that at the Cole gave a pretty good example of it, but at the federal level, the $10,000 per violation for gross negligence. If you lost a flash drive and you did not have a policy and a procedure for mobile computing devices, that would be considered a gross negligence, and at a federal level, that's a $10,000 per violation fine. The state has also has fines, and I think the next slide is another gotcha for our state. Next slide, please. You can be fined by the state, and you can be fined at the federal level, both. But in the great state of Texas, penalties for businesses that do not comply with the breach notification provision, including a civil penalty of not more than $100 to each person per day that is not notified, with a cap of $250,000 for a single breach, and our state says that is possible felony charges. Next slide, please. With that, I think that we finished 1 minute earlier. We wanted to leave 15 minutes for questions and answers. The House Bill 300 dovetails right in with the federal HIPAA. I think that Cole did an excellent job with that. I was just pointing out those things that make our state just a little bit different. The first is that PHI in a review is that PHI affects House Bill 300 impacts everybody. Just dang near everybody, and that in our state a breach of PHI can be constituted a felony. And with that, Veronica, I will turn it over to you and see if we have questions.
Thank you, Terry. And yes, we have some questions. The first one, when Cole was talking about creating a list of entities and vendors that you have contracts with, someone asked, what about the contracted cleaning crew?
As to whether or not they'd be considered a business associate?
Yes, or they should be included in the list of the entities that you have contracts with.
Yeah, so I review all your entities that you contract with, whether or not, initially, whether or not you announce or conclude that they include, any passing of protected health information or not. Just an initial step is include anybody that you contract with, whether they're the, carpet sweep or not the carpet sweep, but the parking lot sweeper or the janitors, or if they're your billing manager or your outside billing company. Anybody that you contract with, make a list, and then once you get that list in place, go through and determine, okay, does contract A involve PHI? Does contract B involve PHI? And analyze it in that manner, That way you make sure you include everybody, and then you can track, your steps into determining who you need a business associate agreement with. That might be cumbersome, and some might feel that might be over the top to do it in that manner, but I feel that's a good manner to do it so that you don't miss anybody, especially with the expansion of the definition of business associates. You might have a contract with a cloud server, for instance, that you might have not thought was a business associate agreement before, so you might not include them in your list. But if you include everybody you have a contract with, you'll include that cloud person, the cloud-based computing vendor that you have, and as you're going through the list, you'll determine, okay, well, they hold our records in the cloud, which involves PHI, and so now under the expansion of the definition of business associate, they're included. So we need to make sure we have a business associate agreement in place with our cloud computing vendor.
Okay, thank you, Cole. There's another question. Will an unencrypted email containing PHI be considered a breach?
If it was disclosed in a manner that violates the HIPAA provisions. Just because it's an email doesn't necessarily mean it was a breach, depending on, if you're emailing another physician, per se, regarding a patient, it's not necessarily a breach unless the disclosure was made in a manner that violates HIPAA, or if for some reason or not the email went to another party beyond the doctor or physician that you're attempting to send it to. So it's not a violation to email, per se, to someone, just like, when you call somebody to discuss a patient, it's not a violation. It's whether or not the acquisition, access, use, or disclosure of that PHI was in a manner not permitted under the privacy rule. In regards to the email, it's just something we all know, the security risk involved with email and how easily emails are hacked. It's just not something to play around with. If you're doing that practice, I advise you to stop. And there's alternative ways to securely transmit that information. There's direct email services that provide encrypted email and other means to transmit protected health information. So it's just a risk, and I feel it's an unnecessary risk to take when you send information in that manner, because most likely there might be a breach of that PHI if you send it in just a regular email.
Okay, thank you, Cole. There's another one. Is it mandatory to submit a notice of breach to HHS if the breach only includes PHI for less than 500 patients?
No, you only need to submit the notice to HHS when it includes 500 patients or more, or 500 individuals or more.
Okay, thank you very much. And that's all the questions I have. No, there's another one. Is it necessary to encrypt data at rest on servers, workstations, laptops, etc.?
Off the top of my head, I'm not sure if the security rule provisions provide that you need to encrypt data at rest or not. I'd have to look into that to see if that's a requirement or not. But my general guideline and guidance is, any data that you can encrypt, you might as well encrypt it so that you take those extra steps to make sure that the PHI is protected. But whether or not it's required or not, I'm not sure. I'd have to look that up.
Okay. Thank you, and those are all the questions I have. Thank you, and well, now I just want to thank both of our speakers for taking time out of their busy day to share their knowledge with us. If you have any questions for today's presenters, please email TexasRec using the email shown, and we will make sure you get an answer. Please join us next month for our next education webinar in the series. We'll be presenting security risk assessments, why they are done, and what should be covered. It is going to be on August the 6th, and hope to see you there. Thank you for attending today's webinar.